Welcome once again to Lehto's Law. Here's Steve Lehto.
We've talked before about home equity theft in the situation where someone doesn't pay their taxes and the municipality takes the property and auctions it off to get the taxes paid. And then in the old days, they would then just pay themselves the taxes that they were owed in arrears, but just keep the surplus. They'd keep the surplus. So if you owed, say, $50,000 in back taxes, but your home was worth $500,000, they would auction your home off for whatever they could get for it. And if it sold for, say, $450,000, they'd pocket the whole $450,000. And they'd say, well, $50,000 that's for back taxes, and everything else was just surrendered or abandoned by the homeowner. And the U.S. Supreme Court finally stepped in and said, no, that's not right. You can't do that. And so since then, there's been all kinds of confusion because a lot of the places where this happened, they're looking at it going, well, do we have to give the money back that we took now? And so there's been a lot of scrambling with legislation in an attempt to make it so that it wouldn't get as painful as it could become. And James sent me notes. Steve, check out this case from the Second Circuit Court of Appeals that just recently came down, okay? And it's a case called Sakorski versus the city of Newburgh and others. And this is happening in a situation much like this. The plaintiff appellant appeals from a judgment of the United States District Court for the Southern District of New York, which dismissed his complaint against the city of Newburgh and others. On appeal, he argues that he stated a claim against the city for a constitutional taking, that he also has a right to recover under New York state laws enacted while this appeal was pending. And so this court says, no, he's got a case. So I'm going to refer to one guy as a homeowner. The plaintiff appellant. It's easier to say homeowner. Plus, you'll remember it better, trust me. The homeowner bought his house in 2006, but he fell behind in his taxes. So the city foreclosed on that house. Sakorski's complaint, the homeowner's complaint, alleges that the city has since sold the house for about $250,000 more than what he owed in taxes, but they refused to give him the surplus. The district court tossed his complaint for failing to state a claim. He argued below and now presses on appeal that he has stated a claim under the takings clause of the Fifth Amendment, and we agree. So he purchased the property in Newburgh for $370,000. 6 years later, after falling behind his property taxes, the city of Newburgh initiated foreclosure proceedings and took ownership of the property by deed pursuant to a default judgment. Afterwards, the homeowner asked the city if he could work out some kind of payment plan to get his house back. They had an agreement, but he fell behind on that. And so at that point, the city sent him an ultimatum saying if he failed to resolve these issues, the city would avail itself of any and all remedies afforded to it under the repurchase agreement. So then they went ahead and got in a scuffle on this. So he sued the city in New York State Court, alleging a bunch of stuff and saying that the repurchase agreement's liquidated damages provision was unconscionable, but the trial court dismissed that lawsuit. In March 2021, he again sued the city, the state court, for damages related to the cancellation of the repurchase agreement. And the state trial court dismissed that claim as well. So then the city sold the property. And here's where it starts getting interesting. The city sold the property to a third party for $350,000. And so this litigation, which would be his third lawsuit, I believe, began when the homeowner filed the federal complaint at issue. And under it, he says there's violations of several things, including the takings clause of the Fifth Amendment. So the joint motion to dismiss that was filed by the defendants was pending before the district court around the same time that the Supreme Court handed down a case called Tyler versus Hennepin. And I've talked about that before. There, the court held that the Fifth Amendment's takings clause, as applicable to the states, prohibits municipalities from using the toehold of a tax debt to confiscate more property than was due. And thus, where local law provides no opportunity for the taxpayer to recover sale proceeds in excess of the tax debt owed, a plaintiff may bring a claim for constitutional taking against the municipality. So some states had a mechanism in place or have put one in since that says that if we do this to you, you can then come after us and we'll work something out, or you can sue us under this statute, whatever. but there was a mechanism for you to recover the surplus. And the Supreme Court said specifically that without such a mechanism, you can bring an action under the Fifth Amendment. So 2 months after Tyler was decided, and seemingly without reference to it, the district court granted the defendant's motion to dismiss. So despite the fact that this Supreme Court case had just come down, the trial court said, nope, you got no case. So this court here, and this is interesting, assigned the homeowner appellate counsel because he'd filed his action. It got thrown out. He filed his first appeal stuff on his own, pro se or pro per, take your pick. And apparently they were impressed with how good his case was, but thought he might need some help with the legalities of it. And so now he's before this court, he's got attorneys, and he's winning this case. So on appeal, he's only bringing 2 claims: the constitutional question and claims under the New York real property tax law for the recovery of the surplus. And by the way, those 2 are parallel, meaning that if he recovers under one, he's made whole. So first of all, in the constitutional taking, which is what the court decides on, the takings clause applicable to the states through the 14th Amendment provides that private property shall not be taken for public use without just compensation. And they actually quote that from Tyler. Despite the fact that they can just quote the Constitution, the court's actually making a point here. The Supreme Court has remained steadfast in the holding that property taxes, interest, and late fees are not themselves a taking, and that the state may also seize and sell property, including land, to recover the amount owed. The novel question Tyler addressed was whether, when money remained after a home was seized and sold to satisfy past due taxes, the remaining value is property under the takings clause, protected from uncompensated appropriation by the state. The Supreme Court unanimously answered in the affirmative, holding that the taxpayer must render unto Caesar what is Caesar's, but no more. When local law provides no opportunity for the taxpayer to recover the excess value, a plaintiff has a claim for a constitutional taking. So here the homeowner alleges the city sold his house for $350,000 to a third party, despite his tax bill being $92,000. So he also alleges the city never gave him that almost $258,000 difference, which is the surplus. If New York State or the city provide this man with no procedure to get that money back, the Constitution indeed does supply a remedy. So Tyler made clear that if local law provides valid procedures by which one might receive the surplus and owners do not take advantage of the procedure, they have forfeited their right to the surplus. So what they're getting at here is that there can be a state statute. And if there is a state statute, you use that one. If not, don't. You can go ahead and go with a constitutional law issue. But they also point out that in this case, the New York state laws do not give this man a remedy. The laws provide an unconditional claim for surplus equity only for those properties which were sold on or after May 25th, 2023, which was the decision date of Tyler. So the state of New York passed a law and said, from the date of Tyler being rendered by the U.S. Supreme Court, going forward, you can get your money back. Prior to that, no. And so there were probably quite a few people who had their surpluses taken before that case came down, because I know in Michigan there were quite a few. And for properties sold before that date, a claim for surplus attributable to such sale may be maintained if and only if a proceeding to compel such tax district to distribute such surplus to petitioner has been initiated and such proceeding was still active on the effective date of this act. And there they're talking about the statute of limitations. But again, that doesn't matter here because the homeowner alleges here that his property was sold in June of 2021 and therefore would have only had a remedy under that statute if he had an active proceeding pursuant to that statute, blah, blah, blah. It gets very confusing. But his property was sold before the date of Tyler. He never brought an Article 78 action in state court, so the New York law does not afford him a remedy. So no party has pointed this court to any local law that would help this man. So the man lacks a local remedy. The Constitution fills the gap. So he's got the right to bring the action, and he's going to win. But the city raised 4 defenses. And the first defense was that they had a repurchase agreement that they were working on. And because he had that repurchase agreement, which he breached, somehow he shouldn't be allowed to get the surplus. But the repurchase agreement didn't actually address that. It didn't say, by the way, if we've got to take your house and sell it and create a surplus, we can keep it. Second, they say the takings claim is precluded. Now, they're clearly just scrambling here trying to come up with something that'll work. So it's not precluded. And then also, they point out that he couldn't have filed his claim earlier anyway, because New York courts, like federal courts, require a claim to be ripe for it to be justiciable, thereby avoiding mere hypothetical adjudications. So they got to go on actual cases, and you can't say, well, I'm about to get hurt. Can you please award me money? You might be able to get an injunction, but that's a different thing. So this court, Second Circuit Court of Appeals, has yet to consider when a claim for surplus equity under Tyler accrues. We hold that the harm at issue is the municipality's retention of the surplus equity. So now they're arguing about whether or not the man should have filed his suit when the house went to foreclosure sale, or whether he should have sued when they refused to give him the money. And this court says, no, his cause of action accrues when they refused to give him his money. So he's good. He filed it well within the time. So the court here ends, and it's only a 13-page opinion. So you got to give him credit for keeping it short. I always like that when they keep these opinions nice and short. None of the city's defenses being meritorious, we conclude that Sakorski, homeowner, has stated a claim for taking under the Constitution. Accordingly, we vacate the dismissal of his claims for a constitutional taking against the city of Newburgh and otherwise affirm the judgment of the district court. Case is remanded to the district court for further proceedings consistent with this opinion. So it is weird, because I remember when Tyler versus Hennepin came out, and the U.S. Supreme Court said if a case like this happens and a home gets sold, creates a surplus, the surplus goes to homeowner. But they didn't address what to do about all the cases where it had already happened. So you go, okay, from here forward, we know what to do. What about all these cases back here? And in some states, the amount of money was so large that it would have been crippling for the states to have to cough it all up at once. I'm not exaggerating. The amounts of money were huge. So many states were dragging their feet, hoping the situation would go away. Apparently, the state of New York passed a law and said, well, if you file an action between when Hennepin happened and the present, we'll talk to you about that. But before that, you got to jump through all kinds of hoops, and it works out to where it's almost impossible to do. And I don't know how the courts would rule, the higher courts, on that particular section of the law. But here they said it didn't apply, because the way the law is written, the guy couldn't have used it anyway. But he had a pending action under the Fifth Amendment that he had filed, and they said, well, he can recover under that. So it's a fascinating case. He filed 3 actions on his own, pro se, pro per, and those 3 cases were all dismissed. But on the 3rd occasion, he filed an appeal, also pro se, and apparently the Court of Appeals looked at it and said, oh, that's fascinating. This guy needs an attorney. And so he got an attorney, and there you go. He wins this case. Now, obviously, if they wanted to, they could appeal this, meaning the state, the city. I doubt that they would. But a bigger question I have is what's going to happen in all the other states, because there were a lot of these cases where people had this happen to them before Tyler versus Hennepin was decided. So here's the deal. It boils down to this. Tyler versus Hennepin said municipalities and states have got to stop doing this. When they create a surplus, they got to give the surplus to homeowner. And on the one hand, they like the free money, so now going forward, we don't get the free money anymore. What about the cases that happened before Tyler versus Hennepin? That's always been the issue. It's always been the problem. So this is a fascinating case for that reason. So again, the case is called Sakorski versus the city of Newburgh, and it's a win for the homeowner. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. They don't know that we know they know we know.